Good afternoon, everyone. We are convening the Committee on Consumer Protection and Commerce. It is Thursday, February 26th, 2026, 2 p.m. in conference room 329. Fun and exciting agenda for you guys today. Vice Chair, go ahead.
Okay, before we get started on testimony, just want to remind folks of the 2-minute time limit. If I have a timer here, if it goes off, I will give you a warning to just wrap up your remarks, just so that we stay on schedule. First up on the agenda is HB 1946 HD1 relating to registration of timeshares. This provides that applications for registration renewal required by section 514E-10 Hawaii Revised Statutes shall be deemed approved upon delivery.
I told you guys, fun and exciting.
Okay, so first up is DCCA timeshare program.
Good afternoon. The department stands on its written testimony offering comments.
Thank you. Hilton Grand Vacations in support.
We'll stand our written testimony in support.
Thank you. American Resort Development Association in support.
Yeah, standard strong support and are agreeable with the DCCA's 3 proposed amendments.
Thank you. And Marriott Vacations Worldwide Corporation in support.
Standard strong support.
Okay, thank you. Anyone else here to testify on HB 1946 HD1? Seeing none, any questions, members? No? Okay, moving on to the next agenda item, HB 1515 HD1 relating to workers' compensation. This bill authorizes an attending physician to request a functional capacity examination and refer an injured employee for the examination without first obtaining permission from the employee's employer in order to assess the employee's ability to return to work. First up is Department of Labor and Industrial Relations and Support.
Afternoon, Chair, Vice Chair, and members. Joanne Fittenhar, Administrator for Disability Compensation Division, representing the department. Thank you for hearing this important working report. The department strongly stands on its testimony, and we're available for any questions. Thank you for allowing us to testify.
Thank you. Next up, Department of Human Resources Development in support.
Here stands by his written testimony in support.
Great, thank you. Anyone else in person or on Zoom who'd like to testify on this measure? Seeing none, members, any questions? Moving on to HB 1514 HD1 relating to workers' compensation, clarifies the process for selecting a certified provider of rehabilitation services, requires providers to automatically approve vocational rehabilitation services for an injured employee if those services will likely be required for suitable gainful employment, and requires providers to file an employee's vocational plan no later than 90 days after submitting an initial evaluation report with certain exceptions. First up is Department of Labor and Industrial Relations in support.
Thank you again, Joanne Fittenhar. We support the intent of this measure, although we do respectfully request some amendments to the measure. I think it will help to clarify our position. We always support improving the work comp processes to make it more efficient and ensure timely return to work for the injured worker. Thank you.
Thank you. Department of Human Resources Development in support.
Here stands by written testimony in support.
Anyone else in person or on Zoom who'd like to testify on HB 1514 HD1? Seeing none. We also had 1 individual submit testimony in support and 7 in opposition. Members, any questions?
Joanne, so your testimony, I believe your testimony said the 90-day provision was kind of a sticking point. Is that right? Was that your testimony or was that someone else's? If not,
It was someone else's testimony.
okay.
Well, actually, it's in our testimony, but it wasn't put in. The department did not recommend the 90 days.
Yep.
And so it's something that we asked to have amended up.
So for the 90 days, I mean, the point is to kind of keep this thing moving is the problem, and I note in the bill with the 90 days, it can be extended if the employer and the injured worker and provider agree. Would it make the department feel better about that provision if we added a kind of a one-time extension based on the voluntary, I guess if the injured employee by themselves wanted it? Or is that kind of the sticking point?
I think the sticking point is that we need collaboration between the providers and the employers. And there's so many steps in voc rehab that to allow them to formulate a proper plan, it's hard to set a 90-day timeline or any timeline on that because of every case is case by case. So it's more complex to say that 90 days unless we have an extension.
But how long can they treat before the treatment plan? Because there's a period of time right before the treatment plan is submitted where the provider can provide healthcare. How long is that period of time?
So the healthcare, not the counselor.
Yeah.
The healthcare can continue for 15 treatments without, but that's not with VR. So that's outside of VR.
Yeah, I'm just trying to
Picture that.
plug that in with the plan. And if they have enough time to treat before the plan is due so they can kind of better evaluate. I thought there was a time frame too. It's not a time frame, it's just 15 treatments.
Well, there's within 120 days.
Okay, so it's a 120-day marker. So if we change the 90 to 120 days, that would kind of line up with the time where you need a treatment plan to continue to treat, right?
I guess with the right of an extension.
Yeah.
The challenge that we have with VR in the Department of Labor is we have a VR unit, but the unit is only staffed with one employee. That's the only person that we have. So for them to be able to, we look at what is most important to move VR forward. And I think it's the initial evaluation, and it's that selection of the counselor to the initial evaluation. And then it's a proper formulation of a plan. So if it takes a little bit longer to formulate that plan, as long as there's justifiable reasons, medical reasons, or someone may not be feasible to be in VR for several reasons. So having that, and depending on the labor market condition, where the individual lives, a formulation may be a little harder for that plan development.
How difficult is it to amend a treatment plan?
A treatment
Or, sorry,
plan
vocational
or a
rehab
VR plan.
Sorry, I keep mixing the
The
two.
VR plan is, again, it goes back to the coordination between the provider and the employer. So each employer or each provider is not as responsive at times, and the director does not have the resources to continue to be on those individuals to move it forward. So we think that if we'd still streamline with some of the amendments in the bill for the selection. And we required but we requested a 7-day timeline to take a reasonable time and establish that to 7 days for notification. I think a lot of times the employer does not know if the employee is wanting to be a part of, because VR is not a mandatory program. So an employee can select not to be in VR. And so because it's not mandatory, they have to choose if they want to select. If they decide that they want to select, then there's the referral process. And once the referral is made and the selection is made, it's a good fit between the injured worker and the counselor, then that selection is made, and they have 7 days is what we're recommending for them to tell the employer about that selection. I think that in itself will help to move the process forward. There are some reasons why someone would not have a plan formulated. And so that's that 90 days that we start to be concerned, because that's all we'll have is more denials potentially. And we have more denials, which is going against the intent to streamline the process, which it may delay a process.
And I do want to keep some pressure on them to get these plans out. I mean, I think most of the cases that you're talking about that extend past 90 days are more extreme cases or cases that are more complex, I should say.
Complex.
So is there some kind of mechanism we could put in place to identify those complex or weed out those complex cases to give them more time?
Well, I think your recommendation to extend it a little bit longer, but there still is gonna be, we always ask for director's discretion, but in this point, director's discretion, going back to I only have one staff member in the VR unit. That makes it really difficult.
How many openings do you have? How many?
There's only one position
Only one
tied to the
position.
unit, and that position is filled. But that one individual cannot process. We have over 500 plans that come through, and that's not an amendment or a modification. That's just the amount of plans. So it can be amended, it can be modified. And so for them to be able to review all of it is challenging.
Do you think if we extended it, then people would start coming in on like the 119th day as opposed to the 89th day kind of
Yes.
thing? Okay, so people are gonna try to stretch it as much as they can.
Yes,
Is that beneficial to them though? I mean, I think, I would think having a plan in place earlier rather than later
the
would allow
hard
them
thing
to-
is that you'll have an injured worker that is not sure if that plan is fit for them. It's hard enough psyche-wise to identify that I'm no longer able to go to my customary job. And so now you're trying to place me somewhere else. And so part of it that we look at is they're not ready to make that decision. And so the counselor has a harder time submitting that plan.
Yeah,
So-
and I understand it's difficult for them to make that decision, but I mean, our goal is to kind
To
of
help
help them get over that
Right.
hump.
With the goal of VR is to return them to work as quickly as possible in a
And
cost-effective
it's,
manner.
you know, it is my hope that by setting some kind of hard deadline, it pushes people to kind of act. I understand there can be disadvantages to that as well.
I think we can take that into consideration, the 120 days with some allowance for with good cause to extend.
Okay, I think 120 days is probably what we're going to recommend,
Cap it out.
but with the ability with agreement to extend to, or yeah, because you said you did not want director's discretion, right?
Well, yes and no. That in a good
What if we
world,
set it an alternative of, we'll give you 120 days and then if everyone agrees, you can extend it or at director's discretion.
so I think something that we could do is take it out of the VR unit and not have the VR unit make that determination, but have our hearings officers make that call. So we'd have to take a look at that. I also have limited staff in
I was
hearings
gonna say, your
office,
hearings
but
officers are backed up too though, right? So
I have more than one.
you just flip a coin and
I know.
yeah, it's
That's
tough.
that's the tough part. You know, we appreciate the bill, we appreciate what we're trying to do to move things forward. VR is a little harder of a challenge to figure out where that right date or time is.
Yeah, fair enough. Okay, thank you, Director.
Thank you.
Any other questions? Okay, moving on to the next measure, HB 1648 HD1 relating to workers' compensation, prohibits healthcare providers from dispensing non-prescription drugs, over-the-counter drugs, and non-legend drugs for workers' compensation patients. Department of Labor and Industrial Relations offering comments.
Thank you again, Joanne Vittenhar. The department appreciates the intent of this measure. It addresses excessive medical charges in the work comp system. We agree that cost containment is very important, but the bill as drafted may unintentionally restrict access to medically appropriate care, including common non-prescription or over-the-counter medications that are often the most suitable treatment for injured workers. To balance cost control with clinical needs, we respectfully recommend allowing providers to dispense these drugs when they are medically necessary and ensuring that any charges do not exceed a prevailing retail price. We also ask that the bill clearly preserves providers' ability to advise or direct injured workers to use these medications as part of appropriate treatment. Thank you for allowing us to testify. I'm available to answer any questions.
Thank you. Department of Human Resources Development in support.
Here stands by written testimony in support.
Thank you. Aloha Billing Company offering comments on Zoom.
I stand on my written testimony in support or with comments.
Okay, thank you. Workstar in support on Zoom. Not present. Solera Integrated Medical Solutions in support.
Good afternoon, Chair Matayoshi, Vice Chair Grantinelli, and Representative Uemoto. I represent Solera.
Don't normally allow props, so I hope that's not a problem.
Oh, I'm sorry, I brought a couple of medications just to show you, show you the difference. So on one hand, thank you very much. Thank you for correcting me. So, on the one hand, maybe there's sort of an undiscovered area that needs attention, and that's really the whole physician dispensing, why we have it in the first place. So one of my suggestions is to limit physician dispensing to the first 30 days following the injury, during which time they can easily transition to the employer's PBM. And specific to 503B compounds, our initial reservations about this legislation was that it prohibited prescribing and dispensing, and I think prohibiting prescribing would be contradictory to 451-1 as well as 386. So we're suggesting this bill move forward with a couple amendments. One including the 503Bs and the prohibition for dispensing, and then the 30-day limitation. And the example that I wanted to show you was a very generic medication like methylcarbamol 500, which when physician dispensed would be $1,379. Versus the actual cost of that medication to the dispensing physician would be $10. And when you think of the average wholesale price, which is our pricing mechanism for medications, that is very, very open to abuse because it is the manufacturer, relabeler, repackager, or the bulk compounder of the drug that reports that AWP to Red Book. And then we're supposed to reprice that AWP with the against the bill charges. However, if that AWP is really not the actual average wholesale price, then I think there's a big problem. So most states have moved away from such pricing mechanisms. But really, I think if anyone wanted to abuse the system and circumvent the existing cost controls. With the AWP, the way it is, it's very, very wide open for that. We're on the front lines of that because we audit medical billings for insurers, employers, government agencies. We're auditing. We work with some of the federal agencies in our audits and in our work. So it's been very, very problematic and has ramped up significantly since the practice began about 20 years ago. So,
Can you wrap up? Yeah.
yes, thank you very much.
Thank
I
you.
know I've exceeded my time, and thank you for graciously allowing me to do that. I really
problem.
appreciate it. Thank you.
Thank you. Anyone else in person or on Zoom would like to testify on this measure? Seeing none, members, any questions?
Joanne again, I think. I just missed someone. So if we roll this bill's language back to the original and then we just apply DLIR's proposed amendments, are you okay with that? Do your proposed amendments apply the same way to the original bill? Would that kind of get rid of your concerns?
I think if we tighten up what this definition of prescription is, so it's not giving that verbal direction, as well as if we don't confuse this with the compound bills, then I think we would be in a better place.
Okay, and your testimony, I believe, took out prescribe and put in another subsection that was just kind of giving advice So that, I'm assuming that's what you're talking about there?
That's what I'm talking about, yes, because when you look at prescription or prescribe, that could be written or it could be oral unless you define it. And so we want to define that what we're really talking about here is the written prescriptions.
Gotcha.
Not to take away the physician's ability to be able to provide oral guidance without writing a prescription.
Okay, thank you.
Any questions? Okay, moving on to the next measure, HB 1644 HD1, relating to consumer protection. Requires a person or entity marketing or contracting for a residential solar energy device to provide the consumer a one-page standardized disclosure form. DCCA Contractors Licensing Board offering comments.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Carrie Shahan. I'm the Executive Officer of the Contracting Licensing Board. We've offered comments on the bill, and I'm here if you have any questions. We'll stand on that testimony. Thank you.
Thank you. DCCA Office of Consumer Protection offering comments.
Good afternoon, Chair and Vice Chair and members of the committee. Thank you for hearing this bill. My name is Mana Moriarty. I'm the Executive Director of OCP. And I appreciate Hawaii Solar Energy Association for bringing this bill forward and starting this conversation. I also think it highlights some of the stark differences in what we think may be meaningful consumer protection that should be included in the conversation. And the bill as it stands represents, I think, decisions that were made among members of the HSEA before OCP was involved in the conversation. So I think decisions were made and compromises may have been made about what was effective consumer protection before we became involved. We've made a number of suggested amendments. We think consumer protections in the conversation should include a 3-day notice of cancellation, mandatory. We think it should include making the contract voidable for failure to provide the required disclosures. We think we appreciate the testimony from the Hawaii Credit Union League, which highlighted the question about whether this extended to lenders. We think that is a fantastic question. Should the voidability extend back to lenders? I think that is a great question. If for example, if you were to, as a consumer, enter into a contract that failed to include this disclosure statement, should you still have to pay the lender who's financing your agreement? We think perhaps the lender may be in a better position to judge the solar installer's due diligence than a consumer would be. So these are some of the issues that I think we should explore. We've proposed amendments there, and I'm happy to leave it there and address any questions that should come up.
Thank you. Next up, Kauai Island Utility Cooperative in support on Zoom.
Good afternoon, Chair, Vice Chair, and member of the committee. Scott Sato from KIUC. KIUC stands on its written testimony in strong support of this measure, as we've experienced some of these experiences here on Kauai and have heard from our members. So thank you for your time.
Thank you. Hawaii Solar Energy Association in support.
Hello, Chair, Vice Chair, member of the committee. I'm Rocky Mold with the Hawaii Solar Energy Association. I'll stand on our comments in strong support of the measure. Just note that we did reach out to DCCA beforehand and worked out a lot of the measures and changed the bill around based on that conversation a bit. So glad to hear that there are constructive edits coming in. We're open to those, of course, but we're in strong support of this measure. I believe it's really important as we drive towards our renewable energy goals, as we increase adoption of rooftop solar and energy storage in Hawaii. I'm here for questions if you have them. Thank you.
Thank you. Anyone else in person or on Zoom who'd like to testify on this measure? Seeing none, members, any questions?
For DCCA, so I think you mentioned the last point I think you made was about lenders. There are are there two universal lenders? One is a lender or financer who often comes in with through the contractor, and one might be a home equity loan bank offering. So those would be two different universes, right? And so I guess when you said the lender would be in a better place to kind of advocate for the consumer, you meant, which one did you mean, or both?
You know, I hadn't sort of appreciated this distinction, and I think, you know, that should apply potentially, you know, to both. The calculation or the calculus that we're thinking of is that the lender is situated better to assess whether the contractor or the installer is in compliance with the disclosure requirement. We've seen this come up in other situations where we have sort of a hard money lender for a property that's being flipped. And we think, and we've taken this position in our enforcement actions, that the hard money lender has a duty of due diligence to figure out whether the contracting parties followed requirements established by law, for example, in the mortgage rescue fraud context. Rather than, in that context, rely on the consumer, homeowner, who was being foreclosed on to determine whether the contract complied with statutory requirements, the lender absolutely should be doing due diligence to figure out whether that installer they're partnering with is operating in compliance with the law.
And I have another question for somebody else. Okay, thank you. And then I have a question for the solar installer. Have you had a chance to read over the recommended amendments made by the DCCA?
Not fully, just saw those today. What I heard sounds reasonable, you know, orally. You know, I'll just reiterate, like, the purpose of this bill is to get everyone playing on the same page and protecting consumers, right? It's about parity in consumer protection and guarding against unfair trade practices. So we're all for leveling the playing field to protect consumers.
Thank you, appreciate that.
Mana. Credit union's testimony, just want to make sure we're not misrepresenting what their testimony is. They didn't testify on any of the provisions you're proposing, the voidability portion or the ability within 3 days to cancel the contract. They are asking for an exemption from the requirements here, but that's in the requirements of the HD1 version. I've looked at your voidability provisions and I think I agree with them, but I'm not sure I agree that the contract or arrangement or agreement between the consumer and the bank should necessarily be affected, even if the person can void their solar contract. That bothers me a little, and I just want to make sure that we know that they were not commenting on. Your testimony seemed to imply that they were okay with that too, or they were at least considering that testimony. Did you speak to them before? Is that why you?
No, what I was focusing in on, I did not speak with them beforehand about it. So what I was reacting to was their testimony, which I think very clearly raised the question of lender liability. So is there lender liability for a violation in the context of the HD1? And I think that is the question that we think deserves a conversation, rather than jump to the conclusion that lenders should be insulated from liability. There is a power dynamic between the lender and the installer that is just not there between the borrower and the bank, or between the borrower and the installer in many cases, where you have a much less sophisticated consumer or borrower who is taking out a significant loan for a financial product that may be in the tens of thousands of dollars. In the event that the contract with the installer falls through, what actually is left for the consumer or borrower to get? There's nothing, because the contract is void. And yet you may have a separate financing arrangement which has the consumer's pen to paper out there and has them on the hook to pay back the loan. But the loan is not backing the product.
The money they didn't pay to the solar company? I mean, unless there's an early payment penalty, which is not too common. I don't understand why the purchaser would be in too much of a worse position, honestly. Also, the credit union is testifying that they really just don't know anything, or they don't have the technical expertise to do it. I mean, you're representing that they do. They're saying that they have no idea. And I wouldn't, if I'm taking a car loan out to buy a new car, I wouldn't expect my bank to go check the car out either. I mean, I don't know a lot about cars. I just was, that's just me. But yet, if I'm taking the loan out to buy the car, I wouldn't expect the bank to be like, okay, well, I don't, Grandma Tioshi has no idea. I'm gonna go down there and take a look and make sure this car is worth 23,000 or something. That I think that's unreasonable. And similar to the solar guys. I mean, I wouldn't expect bank employee to send someone down to my house to check out my roof to make sure I've got adequate space.
I understand the distinction that you're drawing, and I think there is room for a distinction between having the lender sort of know the product and the ins and outs of, whether this was sized appropriately for the house, and having the lender check that the appropriate paperwork was in place. What this bill requires is a disclosure notice.
Right.
And if that disclosure notice is not provided, then the lender could be on the hook for the contract. Now, it seems to me that the lender could easily go through training for their personnel to ensure that the partners who they're working with have the appropriate compliance regime in place to ensure that this notice of disclosure is provided in every single instance. And the remedy here is, if this notice is not provided, then the lender is on the hook, and of course, then they stop doing business with that installer or that operator who is making the loan without compliance with the disclosure requirement.
Stop making these loans entirely because they don't want to risk it too, right? I mean, we run the risk of the other thing, which is a lot of banks just start pulling out and say, wow, we want to risk being on the hook for this. For the 3-day window, I don't think anyone, that's such a short window. If you went on and got a loan from the bank, I don't think there'd be too much harm if it got canceled. The bank there's not enough time to really hail that out at that. But if you're talking about the length of the contract, failure to give that notice, I mean, that could impact the bank more significantly. Now, these aren't, $1 million loans for commercial or for residential at least, but I think I disagree that the bank should have to make sure that the homeowner got proper notice. I mean, why aren't we making the banks give this notice then, if that's the case? Or do you want to do that?
Yeah, interesting question. I'm glad that you raised it. Thank you. No, I appreciate your position and comments. I think these are the types of questions that could be appropriately fleshed out through our conversations with other people in the industry. And what this bill proposes right now is, here's the parameters. DCCA, please go make some rules in consultation with the industry about what this is supposed to look like at the end of the day. Those conversations that occur during rulemaking are also taking place out of the public eye. Those are sort of fraught, because at the end of the day, if we are coming at the rulemaking proceeding with a very different perspective on what constitutes a meaningful consumer protection, we end up exposing ourselves to litigation. But I think the legislature is the better place to be making these decisions about what our appropriate public policy is in terms of consumer protection. If that means more conversations are needed about particular areas like raising cancellation rate, lender liability or voidability, I think we should be having those conversations.
Yeah, I guess I just feel uncomfortable putting it on the banks who have no privity of contract, no real relationship. That's a tough place for the lenders to be in. But after we modify this bill and if we decide to pass it forward, then maybe they'll weigh in on this. Hopefully they're listening right now. I'd call them up, but they're not here, so hopefully they're listening right now and can comment on the next committee.
Yeah, and I agree with you that the lenders, the responsible lenders in our communities are listening. What I'm concerned about is those lenders outside of our communities who don't really care, who have a transactional relationship with Hawaii borrowers. And those are the hard money lenders financing mortgage rescue fraud situations and home flipping. Those are the lenders that will not do due diligence, even if it's imposed on them, and will require our enforcement to check. Thank you for allowing me to.
Can I ask a follow-up? Sorry, and this is, I'm just actually asking you to repeat the example you gave of a similar situation where lenders have the duty to check for compliance.
We've taken that position in our enforcement actions where the lenders have a responsibility to ensure that in the context of a distressed sale, a distressed property sale, that compliance was observed with the requirements of Chapter 480E, Mortgage Rescue Fraud Law. That law requires any transactions involving distressed property to include a written distressed property consultant contract or a written distressed property conveyance contract. So those are mandatory contracts that must be in place under 480E. If those contracts are not there, obviously there's the arrangement between the consultant and the property purchaser, whatever arrangement it is, we're arguing that that is void. We've obtained an award of summary judgment to that effect, so we're having some success with that argument. With respect to the lender, I think the same goes for the lender. That the lender could easily have checked whether this document existed. And they knew, or might know in the context of a risky transaction, that this property was distressed property bought at a value that doesn't meet statutory minimums. So the lender is much better situated in that place to know. And of course, Rep. Matsuyoshi as a litigator has a lot of experience taking the other tactics, so.
Are those the properties we're worried about though? I mean, I thought this bill was to target people who are being taken advantage of, like the guys knocking on your door, not someone trying to flip a distressed property and trying to put solar on a roof and getting a loan from a shady vendor or something like that. If someone's trying to flip a property, a distressed property, I'm a little less worried about protections for them. I'm more worried about the more average consumer getting basically defrauded here. If you're trying to focus this lender obligation based on distressed property sales and flipping,
That's just an example of analogous.
yeah, but
That is the example. I was just responding to that particular example. But I would say our office is aware of consumer complaints to our office where the contract has fallen through and the lender is demanding payment.
has the money been paid to the contractor at that point?
The money has been paid.
Because
The lender is still demanding payment.
if we allow the voidability portion, I mean, the money should be coming back, right? Otherwise, it's just unjust enrichment, I would think. I think unjust enrichment anyway, it's equitable, but you know what I mean.
And if we extended voidability to the lender, it would be clear that the lender could not make a lawful demand on the homeowner in that particular situation.
So it forced the lender to go after the solar company?
The installer who failed to live up to their contractual commitment, correct?
There's no privy of contract between the two, so you'd have to, I don't know how you do that, I'm not sure you have standing for that, right?
I think some factual discovery would be needed to determine if there is some privity of contract or some other relationship that warrants going after the installer in that situation.
Not a third-party beneficiary, I'm struggling to find the legal basis for that, I guess, and that's what that's kind of what I'm getting at with this whole thing, that I don't think there should be, I don't think the lender should be responsible for that, for two other parties' contracts, really. I don't know, I guess I'm just not convinced.
I understand. I think one of the issues that we're seeing is that, and perhaps our friends in the industry could tell me better, what exactly is the nature of the relationship between the installer and the financer? Because I think that relationship in some situations is much closer than many people would be comfortable with if they actually knew what the relationship was.
Which is, can I just say, which I think is different than the banks you're talking about, which is why I was saying there were two universes, where there's a tight nexus between the financer and the installer. Because oftentimes the installer comes and says, I can arrange financing for you here.
Okay. Anyone in the industry want to comment? Let's hear.
I just want to bring it back to the intent of the bill is to really govern the door knocker, folks that are going out there and selling product and misrepresenting it in some way. we've been getting reports of increased activity like that. It seldom happens, it's still a minority, but we heard about it happening a little bit more. We wanted to just proactively clean that up a bit and make sure that we filled this gap where third-party door-knocking entities were not governed by the same rule, clearly governed by the same rules as solar contractors going and selling. So that's really what we wanted to do. There are different ways of financing these projects. There are different universes. It's more than two probably, I would imagine. But the main two really are the cash market, where a customer contracts with a solar entity and then gets financing from a bank through some kind of HELOC or direct financing. The other universe is leasing, where there is a closer connection between the financier and the leasing company. And sometimes there's a contractor that's contracted with the leasing company. Sometimes they're one company that's doing it. But I think this bill covers all of those scenarios.
Okay, thank you.
Any other questions, members? Okay, seeing none, moving on to the next measure, HB 1619 HD2, relating to electric vehicle infrastructure. Excludes from the definition of development as it applies to special management areas, the installation, maintenance, repair, and replacement of an EV charging system. Public Utilities Commission in support.
Good afternoon, Chair, Vice Chair, members of the committee. Ashley Norman on behalf of John DeChamora at the PC. We stand our written comments in support and available for any questions that follow.
Thank you. That was all on our testifier list. Anyone else in person or online who'd like to testify on this measure? Okay, seeing none, members, any questions? Okay, moving on to HB 1571 HD1 relating to condominiums. For purposes of registering a condominium project in an agricultural district, this bill 1 lowers the minimum threshold from projects with 5 units to projects with 2 units, for which a signed statement from a county is required, and 2 requires the project applicant to make a presentation on the project to the neighborhood board if applicable. First up is Hawaii Association of Realtors offering comments.
Thank you, Chair, Vice Chair. We stand on our
Thank you. Raquel Achu, individual in support on Zoom.
Yeah. Chair, Vice Chair, can you hear me?
Yes, we can.
I've submitted some written testimony, somewhat lengthy, I apologize. I'm in support. This is an issue that we have been trying to address within our community, as we have at the very least 5 projects that have bypassed any type of community input and have taken away a significant amount of acreage of agricultural lands and turned into developments that have completely displaced either farmers or ranchers.
Raquel, I just want to make sure you're not driving. Are you in the passenger seat?
No. So, yeah, I mean, I'll stand by my written.
Are you in the passenger seat?
Yes.
Okay, just making sure. Go ahead.
Yes, so it's all written in my written testimony, and it's just an issue that we're trying to work with DCA, which we and Rep. Peruso. So I am happy to answer any questions.
Thank you. Anyone else in person or on Zoom testifying on HB 1571? Okay, seeing none, members, any questions? No, we don't. Okay, moving on to the next measure, HB 1810 HD1 relating to charitable solicitation. Establishes prompt payment and financial reporting requirements for professional solicitors that sell donated or collected non-perishable tangible property on behalf of a charitable organization. Goodwill Hawaii in support.
Good afternoon, Chair, Vice Chair. My name is Katie Chan. I'm the President and CEO of Goodwill Hawaii. Its own 501c3 nonprofit that has been in the island since 1959. And we help disadvantaged populations with job placement, job education, job counseling, and training. Last year, we helped over 8,000 people in these areas find jobs within Goodwill and in a multitude of other sectors. We are in strong support of HB 1810 HD1, whose sole purpose is to enhance transparency among those involved in charitable fundraising and donations. This is a critical step forward to make clarity to those who donate each and every day to what we call donation pods. Right now, there are for-profit companies that have set up statewide. They've more than tripled the number of donation pods on this island, and there is a clear misunderstanding that when you donate to these pods, that it somehow benefits primarily local nonprofits. That is absolutely not the case. And this bill would help bring transparency to those for-profit solicitors of donated goods. The funds that, we also have pods, and the funds that we generate from the collection and sale of those donations goes right back into the programs that we implement on a charitable basis. And so we're concerned if the current charitable laws are not enforced against these professional fundraisers, that we'll continue to see donations being redirected away from deserving charities to benefit for-profit companies. So we would like to address the concerns of the Department of the Attorney General. We are amenable to the delay in the effective date for Section 3 to become January 1st, 2027. However, we request that the amended definitions and the prohibited practices that are described in the bill take effect upon approval, not until January 1st, 2027. But the most
of your remarks.
Sorry?
Would you mind wrapping up your remarks?
Okay. Thank you. But the last thing I would just note is that the AG has requested an appropriation to enforce the provisions of this bill. And we would just like to note that we are one of over 10,000 registered charities in the state that are already paying annually funds into, directly into a special fund that the AG's office is supposed to be using to enforce the Charitable Act. And so, although they're requesting additional appropriation to enforce this bill, they already have the funds they already have the funds to do this enforcement at over 5 million existing right now. Thank you so much.
Retail Merchants of Hawaii in support on Zoom? Not present. Anyone else in person or on Zoom who'd like to testify on this measure? Seeing none, any questions, members? Okay, moving on to HB 2475 HD1 relating to labeling requirements. Establishes labeling requirements for Okolehau products. Department of the Attorney General offering comments.
Good afternoon, Deputy Attorney General Travis Moon. We submitted written comments on HB 2475 in light of the Federal Alcohol Administration Act as it relates to federal preemption and the Foreign Commerce Clause. The department believes that it is unlikely that the Federal Act preempts the bill because the bill does not relate to alcoholic beverage and health labeling requirements. The department also believes that it is unlikely that the Foreign Commerce Clause is implicated because the bill does not violate Congress's purpose for enacting its alcohol beverage labeling requirements. I'm here if you have any questions. Thank you.
Thank you. Department of Agriculture and Biosecurity in support. On Zoom? No, okay, not present. Hawaiian Ola Brewing Corporation in support.
Aloha Chair, Vice Chair, members of the committee. My name is Naihalani Breland. I'm the president and co-founder of Ola Brew and now distillery on Hawaii Island. Our mission has always been to support the growth of Hawaii's agricultural economy and by that creating a more circular economy. In addition to my written testimony, I just wanted to share a little story. About 5 years ago, we entered the San Francisco World Spirits Competition with Okolehau for the first time, just to get some notes from world-class judges. We didn't have a bottle yet, so naturally we sent our Okolehau in a plastic jug with blue construction tape saying FDA approved, Okolehau, enjoy. It became the laughingstock of the competition until the blind tasting began. That jug advanced round after round and ultimately won double gold and best in class at the world's most prestigious spirits competition in the world. Since then, we've earned over 74 international awards. This was the first Okolehau that has stood on the world stage since the 1889 Paris exhibition, as well as the Chicago World Fair in 1893, both representing the Hawaiian Kingdom. The common thread there between our spirits and that represented by our monarchs is that it's 100% Hawaii grown key that makes the spirit. It's that simple. This is not just a heritage spirit of Hawaii, it's also personal. Over 100 years ago in Waikiki, my great-grandfather, Joseph Ahuna, also known as the King of the Bootleggers, was involved in perpetuating this art form. During a time when distillation was pushed underground, he helped to keep it alive. Today, we're working to rebuild this industry here at home for all distillers in Hawaii as a place-based spirit that we can export to the world, for the world to enjoy. The question's pretty simple. If we do not define Okolehau clearly, who will? And if we don't protect it now, what happens to it next? History gives us the answer. With a legal definition, without a legal definition, Okolehau has been diluted, misclassified, and commercialized. When we fail to protect something that's ours uniquely, it doesn't scale, it gets co-opted. That has happened to us too many times. With HB 2475, it ensures that that doesn't happen with Okolehau. By requiring at least 51% Hawaii-grown key and in-state distillation, we anchor the value here. We protect our farmers, our story, and our economic future. Mahalo for letting me testify, and if you have any questions, I'm open to them.
Thank you. Anyone else in person or on Zoom who would like to testify on this measure? Seeing none, members, any questions?
I have a question for the Attorney General's office. Your testimony spoke about that this would not be preempted because it doesn't pertain to alcohol.
Mm-hmm.
But there was so much testimony from alcoholic beverage manufacturers, so I'm kind of confused about, it feels like, yeah, I'm not sure why you're saying that it has nothing to do with alcohol, but all of the testimony and support is saying it's alcohol.
Oh, so there's an express preemption provision in the federal act that I guess it prohibits states from creating their own labeling requirements for alcoholic beverages and health. So that health component is important as well.
Oh, okay.
So like, for example, like the Surgeon General warning that you see on alcoholic beverages, the feds, they regulate that and preempt states from altering that warning.
Okay, thank you for explaining that.
Any other questions? Okay. All right, moving on to HB 1645 HD2 relating to liability. Provides certain liability protections for nonprofit child welfare service organizations that are under contract with the Department of Human Services to provide child welfare services to children and families. DCCA Insurance Division offering comments.
Thank you, Vice Chair. The Insurance Division will stand on its written comments.
Thank you. Department of the Attorney General in opposition.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Lynn Yeomans. I'm a Deputy Attorney General, and we oppose this bill because of the financial burden that it would place on the state. And I'm available for questions.
Thank you. Hawaii Association for Justice in opposition.
Hello, Chair, Vice Chair, members of the committee, Evan Oy on behalf of the Hawaii Association for Justice. You do have our testimony. We do stand in opposition. We did want to express, we do understand the intent of the bill. However, the removal of joint and several liability is concerning from our perspective, and primarily because of the impact that it could have on the abuse victims themselves. Largely what joint and several liability is, it's like a very consumer-friendly tool within the judicial system in order to ensure that the victims are fully compensated for their losses during this time. So, removal of that tool, while we understand why it's in the bill, I think that it does create a lot of uncertainty for victims in their recovery process. So, for those reasons, we do feel as though there are other alternatives from a policy perspective that offer a little bit more balance, such as incorporating the insurance costs into the procurement process, while internal policies can be reviewed to ultimately reduce the abuse cases long term. I think that should be the goal at the end of the day. So, for those reasons, we respectfully oppose the bill and are available for any questions. Thank you.
Thank you. Parents and children together in support.
Aloha Chair, Vice Chair, and members of the committee. My name is Trisha Kajimura with Parents and Children Together, or PACT. We're in strong support. PACT is a statewide social services organization providing services across the state on every island. And we faced a really scary situation last September when we came up for our annual insurance renewal. Our liability insurer had pulled out of the market nationwide, and we went up to the last day of the month to find a replacement. We were very close to not finding any insurance, in which case we would not be able to provide any services. We serve about 18,000 individuals per year. Child welfare services are a portion of our services and contracts. And the insurance companies did name our child welfare service contracts as the reason for not providing us with liability insurance. We have in the last year 2,500 cases for child welfare services. So what we are looking for are solutions so that we don't face this again this September. That's how soon we could face a crisis in this matter. And what we're asking is that we take on only our own liability and not the liability of the state or other parties to claims. When we have to take on the liability of the state, our ability to do this work has become untenable. And so we're asking for your support. Thank you.
Thank you. Child and Family Service in support on Zoom.
Hi, hello, good afternoon. My name is Brady Shmaru. I'm speaking on behalf of Amanda Pump and Child and Family Service. We're here in strong support of the HB 1645 HD2. This bill is incredibly important for nonprofits like ours that contract with the state to deliver child welfare services. The liability protections in this measure are not just technical fixes, they directly impact whether organizations like ours can afford to continue operating. Child and Family Service is a statewide nonprofit focused on strengthening children and families through prevention, intervention, and treatment programs. Each year, we serve roughly 4,000 children and 7,000 families through DHS contracts, and nearly 90% of families we serve experience positive outcomes. But like many child welfare providers, we're facing serious challenges in the liability insurance market. Over the past year, our professional liability insurance costs have tripled, and our coverage options have narrowed significantly. Insurance is required under our contracts. If we cannot secure affordable and appropriate coverage, we simply can't continue delivering these critical services. This bill helps address that risk by clarifying liability protections for nonprofits. I think on behalf of the state, this bill helps stabilize access to insurance and ensures the state can continue partnering with community-based providers. Thank you for your time and commitment. I'm here for questions as well.
Thank you. Shannon Alibato, individual in support. Not present. Anyone else in person or on Zoom would like to testify on this measure?
Hello, Chair, Vice Chair, and members of the committee. I'm Betty Lou Larson with Catholic Charities Hawaii. We did submit written testimony. We support this bill because, as you've heard, organizations are getting to the point where they might not have insurance. they might not be able to continue their services. That's so significant to the vulnerable kids and families in our state. We can't go there and then say, whoops. So we really appreciate this bill. We strongly support the amendments that are in the HD2. We feel that they actually make it so that liability is proportionate to what the services are. So yes, agencies are still going to be liable and accountable for the service they provide. But they're not going to be liable for other services that they're not associated with, it's not under their control. And so we feel this is a fair division that will assist both sides, right? The state's not also going to take on the liability of the organization, so it's cut so that it's more defined, and I think it's cleaner. We really feel that this is something that will help to continue these services and also to continue the work of the people, because if insurance costs go way up in a budget, that means other things get left out. So it's harder maybe to hire people because you don't have service, you don't have the cost to hire new people. So we feel this is really an important thing for our continuity of services to this very vulnerable population. Thank you so much for hearing this bill.
Thank you. Anyone else who'd like to speak?
Good afternoon, Chair, Vice Chair, members. Ryan Toyomura, Shanghai Government Strategies on behalf of Parents and Children Together. You have our testimony here, which in support of this measure. I just wanted to kind of take a moment to kind of reframe a couple of things for your consideration when you're looking at this bill. You know, one of the things that I think it's important to note here is that when looking at, I saw testimony regarding the indemnification language. And I think the issue here, or the focus on that testimony, was that the indemnification language would only mean that the provider is on the hook for any kind of negligence that they would have participated in. But the broad scope of the actual provision itself says anything that arises out of or is related to the negligent act. So as you can imagine, that's pretty broad language, meaning that if a provider has a negligent act, does something that's negligent, and then the state is made aware and subsequently they commit a negligent act, that could be argued that it is related to or arising out from that initial negligent act, in which case the provider is then on the hook for. And so I want to frame this in the sense that, when you look at contracts throughout the state, there are many contracts that are profitable. The person that's seeking the contract is going to make a profit. And I think in those cases, it makes sense that you might want to shift some of that risk and burden and costs on someone who's making a profit. But these providers are nonprofits, and so they're not profiting off in that way. And so what this bill is really trying to do is to balance the field and to say, we're trying to be part of the solution, because the burden to provide this service that would ultimately fall on the state, we're taking on and trying to be part of that solution. And just to seek balance in terms of that liability and risk to be allocated across everybody, the state and the providers together. So with that, I ask for your support in passing this bill. Thank you very much.
Thank you. Anyone else who'd like to testify on HB 1645 HG2? Seeing none, members, any questions?
Thank you, Chair, for the Attorney General's office. So I think the gist of your opposition is the overwhelming liability that taxpayers, the cost that taxpayers will face. But if all of these contracted providers, if they can't get insurance, if they have to pull back from servicing the child welfare demands that the state actually needs to provide, and so the state goes out and contracts, if everyone pulls back, wouldn't there be a lot of liability that we would face just by the mere fact that no one's taking on these contracts?
So, first of all, when we're talking about the liability in the tort litigation realm, the state, you guys all vote on AG1, our bill on the tort liability. So the state does take on a tremendous amount of liability in these cases because we are a separate party, we are separately sued. So that's why we pointed out in our testimony that the indemnification is limited to the acts of the particular contractor at issue. And yes, we do acknowledge that the insurance situation is a complex and difficult problem that we are going to have to resolve. And our testimony includes that the procurement process is one process that we'll have to explore in terms of resolving this particular issue. We will also have to explore, I think, policy solutions about tort liability in order to make sure, because if what we're saying is to make this functional in order for the nonprofits to provide these services, I think we have to wrestle with, are we saying that the state has to assume that liability, take on a greater portion of that cost? And I think we have to be explicit about that if that's what we're gonna do. And so that's kind of the questions that we have, is if what we're saying is to make this insurance market work, that the liability has to go to the state, or, you know, there has to be some other way to address the amount of that liability, then those are significant policy questions that I don't think are properly raised in this bill.
Can I ask a follow-up question of the AG? So this bill, from what I understand, it also puts a cap or limits or doesn't allow for punitive damages. Isn't that a huge part of liability? So isn't that a positive for the taxpayers ultimately?
So the Department of the Attorney General doesn't have a specific objection to those portions of the bill. It's on the prohibition of allowing the state to include in its contract the standard language regarding the indemnification of the state for the acts of the contractors, agents, or employees, and the prohibition on requiring insurance to back up that indemnification.
One more. Okay, sorry.
I've got a couple too, but go ahead, last one.
Okay, last one. So there's other ways that we can kind of minimize that by actually having staff trained to go in to these providers and actually do a better job screening, making sure there is no negligence happening, making sure there's safeguards and procedures. Couldn't we invest more in our state workers to go into these organizations to make sure they're crossing their T's, dotting their I's in terms of child safety?
I mean, I think, so two things. One, I don't want to speak for the Department of Human Services and their ability to hire folks who would be able to, do deep dive into the management of particular nonprofits. That's sort of outside my particular area of expertise, whether or not the Department of Human Services would have the funds and the capability to hire staff to do that kind of level of management analysis of the particular nonprofits. I could give you an answer, but it would be just, nonsense thoughts. But, I think this has been such a common part of the way contracting has been done through the state that, and for, we believe, legitimate public policy reasons and for legitimate concerns of, the state and, stewardship of contracts and services that are provided to the state. So that's why we're in opposition to prohibiting it by law.
So I guess I'm trying to get my head around this indemnity issue. When we say that the organization is going to indemnify the state, does that mean that if the state does something negligent, the organization has to indemnify the state for that act? And I believe you said no, right?
I did say no, and if you read, so in our testimony, we specifically include the language of the indemnity clauses in there. The standard general conditions require indemnity for harm or loss, and this is the quote, arising out of or in connection with the acts or omissions of the provider or the provider's employees, officers, agents, and or subcontractors.
But if liability is joint and several, does that even apply then?
So joint and several liability, that assumes there's a judgment, right? So the plaintiff has secured a judgment against multiple defendants. And joint and several liability makes sure that the plaintiff doesn't have to sort of guess at their own peril if everybody's gonna pay. And joint and several liability isn't a strong interest of the state. We don't have any objection to eliminating joint and several liability because, as I said earlier, the state is paying its judgments. This is not a situation where the state is not paying its portion of the judgment as, you know, agreed upon in a settlement or as found at the end of trial. The state is covering those with, you know, the funds appropriated by the legislature. And we are not using joint and several liability to make the plaintiff try to get money
Give me an
from the
example of
contractors.
how, if the organization, if PACT is indemnifying the state, what's the situation where that indemnity provision would kick in?
So if a plaintiff were to sue the state as a defendant solely and not sue PACT, yet the harm caused was the result of the negligence or potential wrongdoing of an agent or employee of PACT, then the state would include PACT in the lawsuit and ask that PACT cover the cost of the harm or loss done by the negligence or wrongdoing of their employee and cover that with the insurance.
Even without this indemnity provision, wouldn't you add them as a co-defendant anyway? Wouldn't you drag them into the lawsuit anyway, though?
The plaintiff would have that choice.
You couldn't force them in as a co-defendant?
You know, we would use this indemnity clause as the way to get them involved in the lawsuit, as making sure that we as the state weren't responsible for the negligence or wrongdoing.
So you're saying you need this indemnity provision to add them as a co-defendant? You couldn't make a third-party claim against them? I mean, it's been a while since I've been a litigator, I guess, but why can't you just do a third-party complaint against PAC then in that situation?
You know, this is what we've been using as a state in order to make sure that we aren't taking responsibility as a state for the negligence or wrongdoing of our contracted service providers. I mean, this is why it's been in the general conditions for all contracts, because this is not just, you know, as we explained in our testimony, this is not just for the child welfare services organizations, right?
I understand.
This is for all.
It just seems like there's a legal mechanism that you wouldn't necessarily need that. Now that being said, because there's that mechanism, maybe it doesn't do any harm to the other organizations to have this indemnity provision in there anyway. I'm just kind of struggling with whether or not we should include this at all. You know, let me touch on a different subject that's kind of related. The additional insured question is also in here in section 2. Does it typically cost money? Or my impression, my recollection is that it really doesn't. But does it ever cost money to add an additional insured to an insurance policy?
So, you know, I am not an insurance expert. I mean, that would be a question for the
Maybe I could ask Catholic
my
Charities.
fellow employee, state employee of the insurance side, but
Whether it costs money to add an insured to a policy.
Add an additional insured. Does it typically cost more? Sure.
To that point, Chair, I think that would depend primarily on the situation. I mean, to the best of my knowledge, that would just be like obtaining basically it would be a stacking of policies. So you would just go and get an additional coverage. So, you know, you get 2 policies that would match you up to whatever cap you're trying to get to.
Adding an additional insured is just adding another person insured under the same, or another entity or person, I guess, insured under the same policy, right?
Yeah, so I mean, I think in that situation, if you were to add, well, let's take the example of PACT and the state of Hawaii. You know, I can't imagine that would incur an additional fee. However, that would be decided upon the individual insurer's process. You know, if it results in additional paperwork administratively, I mean, it's up to the insurer whether they want to tack on a fee, but I couldn't tell you right now whether I can't imagine it's like a significant fee if there even is one.
Okay. Can I ask PACT or Catholic Charities to comment on whether you guys are against being added as additional insured as well? I'm taking it. Why? Well, what's the issue here? unless there's a significant,
Sorry, I don't understand.
are you is the reason you don't want to include the state as an additional insured, is there a monetary reason behind that? That you pay an additional fee for your insurance company to add them as an additional insured, or is it just that you think the state might cannibalize the policy? I mean, I'm just kind of wondering why you're fighting for that at all, I guess.
I'm sorry, I don't know the answer to that. I can find out what happened in our last renewal with that particular cost for that item.
Yeah, I'm just curious if it affected it at all, but you can get back to us with that. Thank you.
Sure, I can answer a question regarding that. So real quickly, you raised a really great question about defense and how they could bring in, notwithstanding the indemnification provision. And so joinder of necessary parties is a defense often brought in by defendants in litigation, and so is a claim for contribution. But that's separate and apart from indemnification, right? Because if they were to bring those defenses, the indemnification provision would kick in and would say that notwithstanding what the judgment is, we as the providers are indemnifying the state. So if there's an adverse judgment, we're going to take care of the claims, the judgment that's adverse to the state. And so they can still bring us into the litigation through those mechanisms. But the indemnification provision, which is contractual based, would put the providers on the hook for the judgment. And that's where the issue comes into play, if that makes any sense. So it's the defense it's one thing to have the defense, but the indemnification provision says notwithstanding that defense, you still have to pay for the damages that I may have caused. Excuse me, I may have caused.
It's only if you can trace it back to them anyway, though, right? I mean,
Well,
and if you could trace it back to them anyway, why wouldn't you just be able to hit them with it anyway?
I think that's the problem with the language that was quoted in the testimony. It says arising out of or connected to. So if you have an initial negligent act by the provider, but some act that is connected to that original act by the state is negligent, all those acts could be deemed connected to or arising out of that original negligent act. So even if the state was fully at fault for doing something negligent, because it's connected to that original act, they would be swept up under that provision, and that's a problem.
Okay, and is that the standard language for state
As-
indemnification, or PGs, I don't know if you wanna, is that the standard language for the kind of the larger nexus?
So yes, that's the standard language that's in both child welfare services contracts and the 103D. It's arising out of or resulting from the act of omission.
Okay, and this is gonna sound like a silly question because I think I know the answer to this already, but the foster parents, they're not considered agents of the state somehow, right? They're if they had a bad act, there's almost no way that that liability could be imputed onto the state. Is that
That's correct. We don't have contracts with the resource caregivers in the way that we would with the nonprofit providing services. So this language is not, yeah.
I think that, but I was pretty sure it was not that way. Okay. Is there any chair here? Okay, all right. I'm good. Thank you all.
Okay, moving on to HB 2301 HD1 relating to school licensure. Transfers the licensing authority of private trade, vocational, and technical schools from the DOE to the Department of Commerce and Consumer Affairs. DCCA in opposition.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Nadine Ondo, Director of the Department of Commerce and Consumer Affairs. And so as we put in our written testimony, we are opposing this transfer that's, I guess, requested by the Department of Education to transfer private trade, vocational, and technical schools to be licensed under the Department of Commerce and Consumer Affairs. And this wasn't how the bill, as I understand it, was originally crafted. The measure did not have it transfer from DOE to DCCA. Somehow that happened in an amendment. And so we now see this bill and we say, this really does not fall within
our mission, our expertise, or existing regulatory structure of anything we license. You know, our core functions are the individual, professional, and vocational licensure, enforcement of unfair and deceptive trade acts, practices against those, and general marketplace oversight. So we do not do anything currently within our department that evaluates curricula, instructional quality, educational outcomes of any educational entities. This is entirely outside of anything that the DCCA currently does and which its mission and core functions involve. So we did note in our testimony that back in 2015, there was a working group that was assigned through a concurrent resolution back then for there to be some discussion between DCCA and DOE about this very matter. And as a result of that, the working group came out with a report that I believe it was in 2016. And basically the problem was, and which was identified from DCCA's standpoint, was that because you're not really talking about a large number of licensees or licensed schools, the cost recovery model that we would have to impose would end up increasing the financial burden on these small schools providers because of the way that our structure works. As a self-funded department, you know, we would have to increase licensing fees in order to cover the expense of regulating and providing the licensure for these schools. So if right now I believe there's only 16 schools. So if you do the math on this, I mean, if we would have to incur the expense to develop the structure, the infrastructure, and the resources to be able to now regulate this program, we would have to divide that up and set licensing fees that would probably make it somewhat cost prohibitive. And then typically, the way schools operate, those get passed on to the students. So the more that it costs to obtain a licensure through our department, the more that's going to increase the cost to get that education from students. So it's just a mismatch. It makes no sense for it to be placed within DCCA, and I'm available for further questions.
Thank you. Department of Education in support.
Good afternoon, Chair Matayoshi, Vice Chair Grandinetti, and members of the committee. I'm Heidi Armstrong, Department of Education. We do stand in strong support as shared in our written testimony. In addition, I would like to share that the department has no preference over which agency or which entity these responsibilities are assigned to. The department stands firm that these responsibilities don't fall under the scope of the work of the Department of Education. Thank you.
Thank you. Anyone else in person or on Zoom who'd like to testify? Members, any questions?
Anybody? All right, department fight. Can I get you guys both back up here? So, let's start with DOE. The bill would transfer all of the positions from your section that licenses these vocational and training schools to whatever other department we put it in, UH, DCCA, another department. How many positions are we talking about here?
It's not even a full-time position.
Okay, so it's just 1/2, like a 0.5 FTE. Who does it now?
An employee in our Office of Curriculum and Instructional Design.
Okay, and they do something else with the other,
Yes.
okay. How much of their day do you think is taken up by this? Because it's just 16 schools, so I mean, is it a true half
It's 16 schools and we don't vet their curriculums. We're processing their licensing papers. Our message is that we're the Department of K-12 Education. We're issuing licenses for massage schools and haircutting
It's
entities
weird,
and
don't get me wrong,
helicopter
but how much
flights.
is this employee working 20 hours a week to do this every week, or? I mean, I'm just trying to
I have the
gauge.
employee here, she can tell how many hours she works.
We have a program specialist, I'm not the one that does the licensing, but he does work 20 hours a week. We also do exemptions for schools that come to us that don't need to follow this license process.
Is it really taking 20 hours a week? I mean, or is it just 20 hours of his time needs to be dedicated to this on the books kind of thing? I mean, how much, I just want to realistically know how long this takes. It's just 16 schools, I mean, that's,
20 hours a week.
20 hours.
20 hours a week.
20 hours a week for 16 schools for the
Maximum.
whole year? That's a crazy amount of time, though. I mean, no?
So it's not only, so it's not only overseeing the 16 schools, right? So again, schools come for us for exemptions, schools that have closed before. Also, students come back to us to ask for their licenses for closed schools, so we keep records for closed schools that have happened in the past. So we've had at times, right, like 40, 50, 60 schools since we've had this responsibility since 1939. It's currently 16 schools. So he does take care of not only the 16 schools, but past students, past exemptions that we might get.
I just used the very advanced calculator on my computer. I mean, 20 hours a week, 52 weeks, 16 schools. Granted, there are other things too. That's 65 hours per school that this employee would have dedicated.
It's not a significant amount of time, and that's not our issue. Our issue is that the whole content of this falls beyond the scope of K-12
No,
Department of
understandable, but what I'm trying to gauge is whether DCCA or UH has a legitimate claim on how much time it's going to take them to do if you were to transfer it to them. So what I need is a realistic estimate from you folks, how much time this is actually going to take, because that's what you're tossing to another department, right? So that's what I'm trying to gauge. So if it really is 65 hours per school, okay, then but that's what I know we're gonna be saddling DCCA or UH with.
To give you a
It's not,
correct
though.
number, we'll go back to the actual employee
Okay.
and see out of that 20 hours, what is devoted to these responsibilities, and we can get that back to you right away.
Okay. DCCA then. I don't think it's probably really a full-time, a part-time, full, like.
I think,
FTE.
I think our point is, this is not something we license or regulate, an educational,
But I mean, we're talking
institution.
about vocational, technical training, I mean, you guys do.
But it's not something we do. We don't license, we license individuals in those particular professions, but we don't license or regulate an educational, school. And we don't do that. So I mean, we are really talking about having to stand up something that's significantly different from anything our department does. And it really doesn't really fall within our core mission.
But you can steal their, I mean, not their person, but you can steal their process.
Okay, well, I mean, I understand that, but I mean, when I'm looking back at, and this is why I did mention the 2015 working group, because this issue has come up before. And I think it had come up at that time, probably for the same reasons. They're saying, this isn't, we're focused on K through 12, this isn't something we do, but they've been doing it. I think, and I'm looking at that study.
They've been doing it
They're
well.
a very long time. And so when it comes up in 2015 and they have a working group on it, DCCA and the DOE had a working group discussion. And then when I'm looking at what their different, of course, recommendations, basically DCCA is taking the same position I'm taking here today, that it really doesn't fall within our wheelhouse to do this, and it isn't really impacted in terms of consumer issues, very minimally. So DOE at the time had indicated, of course, they did say that it's misaligned with their primary mission, and acknowledges that it's not compatible for them to continue to do this regulatory program. But when they discussed if oversight should remain status quo with them, this is what the DOE said they would seek. And among the things that they cited was to basically increase the fees for the licensing, and to request startup general funding of approximately $100,000 per fiscal year for 2 years to create and establish a PTVT program office with personnel and operating costs. Okay, so this is a report that goes to the legislature in 2016. 2017, I believe it was noted in the testimony, in their testimony, I think it's Act 164. So in 2017, in Act 164, this did provide for establishing, I guess, a higher licensing fee schedule. And among other things, provided for that $100,000. And another position, a particular, one position. I mean, so these are things that happened in 2017. There was no mention at that time about it needing to be put in some other department somewhere else other than the DOE. So this is what happened. 2017, that's what we had. So it seems to me, and I understand it's a continuing issue that it's not within their core mission, but certainly it is not something to be placed with DCCA. So that's our position on it. It doesn't make any sense. And because we are specially funded, we do not rely on any general funds. In order to be able to pay for this, to have the expense of being able to regulate this and stand something like this up, this is going to have to come from what we charge for the licensing, because that's how we fund our operations. So that's the difficulty. That's what we talk about, how this is going to increase the costs to attend these schools. And that is what, to me, would be actually harmful, you know, in terms of workplace concerns.
Isn't this one of the reasons why we should raise your fees that haven't been raised in a decade though?
That's a different question, and we can discuss that some other time with regard to the licensing that we do of particular professions. But with regard to something like this, if this comes to us, this is what's going to happen. If there are only 16, I think it's 16 schools currently licensed, this is going to be, it's a small group, and so the cost of what it's going to take to be able to regulate and license these schools is going to have to be divided up among these
Or does the
16.
funding come from the electricians, the public, you know, whatever trade is related to these trade schools? Why wouldn't it come from them? I
Well,
think there's a
I
sufficient
don't,
nexus.
I mean, I'm just saying these institutions, these are private companies. Now, whether or not somebody's going to pay for that is a different question, but what we're going to have to charge is going to have to be based upon what the costs are and the expenses are for us to be able to regulate this.
Everyone's
This is the
private.
model
Plumbers, electricians,
work on.
They're all private companies that are you're licensing. I guess I do see the nexus between that, I mean, continuing education, this is education. I'm not sure I quite buy there needs to be a separate fee sort of thing. I think that you probably could take it from other areas where the trade or vocational schools are training in to license them. And it also doesn't seem just like a very heavy lift, that's all. And you folks do have the experts that already in these areas. No, your point is well taken that they're not, you know, an electrician is not necessarily an electrician teacher. So the educational aspect of it, I think, is different.
Yes.
But it also just doesn't seem like very heavy lift. I mean, it just doesn't, it seems like you guys are fighting over something very little.
Well, I'm just saying, since it got placed with DCCA from when the measure began, and I hear DOE being very thoughtful about the fact that they're not necessarily saying they're leaving it up to the legislature to decide what agency or department should handle this. But I'm here basically to speak on behalf of my department, saying we do not believe this fits within our core mission, and we would have a problem with having to figure out how to stand something like this up because it isn't something we currently regulate.
I mean, if it's time you need, we can set this for one year out and give you guys time to figure it out before it comes over to you.
No, I have a problem with, it's not a matter of time.
So who's
I have a problem with
who's
the
the-
concept of doing it and sending it over to
Who should it go
DCCA.
to then? Who's the next department?
I'm not
above us?
saying who it should go to.
Right,
I'm
but
simply
I'm
not
asking
saying
if you
it
have
shouldn't be
any
coming
idea.
to us, and I don't believe that's my responsibility to you is to say it should go to someone else and not us. I don't believe that is falling on me.
Well, I mean, if you don't want it to be you, then who?
Well, I don't know
It's not really
why,
coming
I
to us
don't
with
even
the
know
actual
why
solution.
it's coming to us.
Well, it's written in DOE's testimony.
Is the DOE saying that?
The DOE is saying, I believe you're saying that,
We're just saying it can go to, we're not prescribing where it should go, we're just saying it
if
should go
not the
outside of us.
DCC, if not DOE, then surely the previous committee put it with you guys for a reason. And I can see the logic there.
I don't know what was going on with the previous committee. We weren't indicated to be the, to be the transfer
Have you spoken to
department.
the previous chair about this?
To the chair about why they amended the bill to put it with
Which he goes
DCCA.
in, Yeah.
No. Honestly, I haven't done that. But I am here to testify in opposition, and we do not believe this is appropriate for it to be transferred to our department.
Do you think UH is? UH was the original. I mean,
I don't know what the circumstances were and what UH's position was or how it ended up. Who suggested it should go to DCCA? I don't know. We didn't track that, we didn't track the hearing, so I'm not sure how this happened. But I'm here to say it shouldn't be transferred to DCCA.
okay, DOE, can you come back up? So honestly, I kind of wish this had all been worked out at the department level before it came to this. It doesn't seem like really a matter for the legislature to try to figure out. That being said, you folks have been doing this for a decade plus.
Yes.
Probably long, how long have you been doing
Decades,
this?
since
Decades.
1939.
You
Yeah.
did get more resources as pointed out by DCCA. Is this bill kind of an admission that you haven't been doing a very good job for decades, or?
No, not
I
at
mean,
all.
what's going on
It's
here?
when we look at K-12 education and what our scope of work is, and this isn't a new bill, it's come up before. And we're just sharing in our testimony that this falls outside, we have been doing it. We've been probably doing it very well. It falls outside of our K-12 mission.
I mean, arguably it does, right? I mean, DCCA did make a pretty good point on that. Anyway, I think my point is, it sounds like no one wants it. It sounds like you guys are, by your admission, are doing a good job with it. And it sounds like it doesn't require a ton of time. So I'm just wondering why there's this, what was the impetus for a
Because
bill?
it's misplaced and it needs to find a different place. It's not the department's kuleana to say where it should go. The department is saying it just doesn't belong in our department. It doesn't fit within our vision, mission, and our K-12 obligations.
Yeah, go ahead, Representative Wabona.
Thank you,
Representative
Chair.
Wabona.
Thank you. Is it possible that your staff person who manages it now can actually do a survey across what other states? Who is licensing vocational schools in other states? You know what I mean? Like, I feel like when we get to that question or that answer, we're gonna discover it's the DCCA. It's the equivalent agency because these students are consumers. They're paying to go to these schools, right? So if these schools are fake and not giving them the skills to actually then put it into practice and make a living, then that's a consumer, that's like a scheme, that's like a victimizing scheme on consumers. That's why I totally understand why it should be with the DCCA. But do you think your staff person can start gently surveying other states to get to this answer?
We do
In your
have,
testimony, it's a little bit there.
Yeah, we do have some information on what other states are doing, and it's in there, and if
It doesn't say where they were though, it says they were in separate boards and agencies outside of the respective departments of education. But do you have information to further clarify that?
Okay, yes,
Expand on that?
thank you. Arizona has the Arizona State Board for Private Post-Secondary Education Licenses. California has the Bureau for Private Post-Secondary Education.
What grade or departments are these housed in?
Minnesota has, pardon me?
What grade or departments are these housed in? I'm assuming these are not standalone just for this.
Let me see. In California, it falls under with the state of California's Department of Consumer Affairs. In Minnesota, just says the Office of Higher Education in Minnesota does the licensing, and in Oregon, the Higher Education Coordinating Commission in Oregon does the licensing.
Okay. So it sounds like it is between kind of the university system and some DCCA-ish departments in other states. Are there any states that have it go through the Department of Education?
I don't have this in this piece of information, but if there are, we can look and send that information to you.
Thank you.
Thank you.
Okay, moving on to our next measure, HB 1889 HD1 relating to school psychologists. Creates a school psychologist working group within the DOE to recommend actionable steps or proposed legislation for an immediate pathway to licensure for school psychologists that can be acted upon in 2027. DOE in support.
The department stands on its written testimony in support.
Thank you. DCCA Board of Psychology offering comments.
Good afternoon, Christopher Fernandez, Executive Officer to the Board. The Board stands on its testimony, supporting the intent and offering comments.
Thank you. Hawaii Psychological Association offering comments on Zoom.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Alex Lichten. I'm the Legislative Chair for the Hawaii Psychological Association. Thank you for the opportunity to offer comments. HPA does support the licensing or credentialing of school psychologists. We are an important stakeholder in the process, but are excluded from the proposed working group in HB 1889. We were included in past bills which did not pass. Therefore, we are asking for an amendment to include HPA in the working group. Given the position by the school psychologists that they are part of the same profession and should be licensed by the Board of Psychology, that very much does affect us. Regulation under the Board of Psychology means that school psychologists would be added to the Board of Psychology and thus act on licensing complaints against psychologists. Psychologists are not qualified to judge licensing complaints against school psychologists, and the reverse is also true. These are two entirely separate professions. The layman may be confused by the term, quote, school, unquote, in school psychology. We merely advocate for a scope of practice consistent with the school psychologist training to perform special education needs assessments and do counseling for commonly encountered behavior problems in school. The best way to ensure that school psychologists are finally licensed or credentialed in Hawaii is to have all the key stakeholders in the working group. All of us need to work together towards that, and thank you for the opportunity to testify.
Thank you. Hawaii Association of School Psychologists in support on Zoom.
Aloha, members of the committee. My apologies as I'm not feeling well that day today. My name is Leslie Bonnick, and I am the Legislative Chair for the Hawaii Association of School Psychologists. I want to start off by saying I stand on my testimony. on behalf of our organization. We are not amenable to having the Hawaii Psych Association or any other private organization have a say in school psychology. School psychologists were added at the doctoral level about 7 or 8 years ago, and school psychologists, and we were not included in that, which was kind of interesting. I heard something that the rep said in the last hearing when it's kind of been kicked back between DOE and DCCA, and it's like, if not you, then who? I started on the work group 15 years ago with the Hawaii Association of School Psychologists to get credentialing in Hawaii for school psychologists, as we are the only state in the nation without one. We went back and forth between HSTB, HSTA. We even pursued like talking to HSTA and looking at doing a union move. It would require a labor law change in order for school psychologists to be with a Hawaii Teacher Standards Board and be part of HSTA, so that was not a viable option, which means DCCA really is our only option left. With the Psych Pact that's come out with our national association, we're seeing more and more states offer credentialing for school psychologists under their similar organizations to DCCA. I'm available for any questions that you might have for us. I did write the first draft of this bill back in 2014, so this is something that I've been pursuing for quite a long time. Thank you so much for allowing me to testify.
Thank you. Alec Morentic, individual in support.
Aloha, Chair and member of the committee. Thank you for giving me the opportunity to testify about this bill. My name is Alec Morentic. I'm a school psychologist on the Big Island, and I support this measure as is. The National Association of School Psychologists is the ultimate voice in the scope of practice for school psychologists, which is why they are named in the bill. The Board of Psychology also is made up of clinical psychologists, so I feel like the concerns as far as other psychological practices and where the boundaries of those scopes are would be well represented by the Board of Psychology. So I support this measure as is, and thank you for the opportunity to testify.
Thank you. Anyone else in person or on Zoom who would like to testify on this measure? Seeing none, members, any questions? Moving on to the next measure, the last measure, HB 1840 HD1 relating to education, requires the Hawaii Teacher Standards Board to develop an alternative pathway for a visiting international educator permit aligned to the duration of the educator's J1 visa program. Hawaii Teacher Standards Board in opposition.
Thank you, Chair Matayoshi, and committee members. We respectfully stand in opposition. I'm Mitzi Higa speaking on behalf of the Hawaii Teacher Standards Board. We already have, anyone with a J1 visa can already apply and get either a permit or a license depending on their qualifications. So this path is already there. We don't have permits or licenses based on where someone is from. So we just have them for whoever qualifies. So there are J1 visa holders that have licenses, there are J1 visa holders that have permits, and they are moving to the licensure. This bill, basically, when Hawaii Teacher Standards Board was created, it was created separately, as a separate institution from the employer on purpose, so there wouldn't be a conflict of interest. The Standards Board is set with the mission of making sure that our keiki have qualified teachers in their classroom. And there already is a path. So we feel this bill is unnecessary. There's more information in our testimony. I don't want to go on, but just part of what our bigger concern, and we have it in our testimony, is about the J1 visa holders. It's not about this license. It's more about loans that they got from private lenders in other countries to come here. That is a bigger concern. When we went to NCSL, that's what they brought up to us. It happened on the East Coast states first, and then it came further over, and now it's here. And they were warning us that that is the bigger concern financially for these J1 visa holders. But it's in my testimony, and make sure that you understand, though, that Our mission is to have highly qualified educators in our classrooms, and we already have these paths available for anyone who applies. And thank you. I'll be available for any questions.
Thank you. Department of Education in support.
Good afternoon, Chair, Vice Chair, members of the committee, Tammy Chun, Deputy Superintendent. The Department of Education supports this bill. Our J1 teachers, there's 365 of them currently. They are able, because of the way that the licensing and permits work, these teachers are able to stay for 3 years in Hawaii, even though their visa would allow them to stay for 5 years if we had a way for them to continue to be permitted. So this bill would create a pathway for a permit for these teachers to stay for 5 years, which is the duration of their visa. I did want to mention that something that's really important is that the J1 teachers, like our other emergency hire teachers, fill positions that we do not have fully licensed teachers for. We have not enough individuals who have a full teacher license available to fill all of the positions in schools. So the question is, what's the alternative to extending our J1 teachers? The alternative currently, our current alternative, is to recruit new ones, new J1 teachers or new emergency hire teachers when we don't have a licensed teacher, or to have a substitute teacher. Those are not better options for us. The J1 teachers receive support when they come. They receive training, and they are evaluated annually. They are only continued if their performance is satisfactory. So I'm happy to answer questions about this, but wanting to let you know one other thing is that the shortages that J1 teachers fill are disproportionate based on geography. So our neighbor island schools are very dependent in some areas on having these teachers. So for example, we have over 100 J1 teachers in Central and South Maui. So the impact is very different on Oahu compared to the neighbor islands, and this is helpful to extending teachers who have already worked in our schools, been evaluated as satisfactory, and are able to provide continuity and education for our children. Thank you.
Thank you. Teacher Lounge in support on Zoom.
Good afternoon, Chair, Vice Chair, and members of the committee. Thank you for the opportunity to testify in strong support of HB 1840 as shared in our written testimony. I am Jimmy Brazelton, Executive Director of Teacher Lounge, the sole visa sponsor partner of J1 exchange teachers of the Hawaii Department of Education. This bill does not lower standards, and it does not change licensure requirements. It simply aligns Hawaii's temporary licensure period with the existing 5-year J1 visa timeline, similar to many other states. J1 visa is a federally authorized cultural exchange program, not a labor program. Its purpose is the exchange of teaching practices, global perspectives, and educational collaboration. These educators are not here to replace American teachers. They are here to contribute to and learn from Hawaii's schools while meeting the same licensure standards required of all teachers. Currently, effective teachers who are actively progressing toward full licensure can be forced out after 3 years due to logistical barriers like testing access, scheduling delays, and the significant cost of multi-part exams. These are timing challenges, not quality issues. Other states, including California and Texas, already allow participation for the full 5-year J1 period with no evidence of diminished teacher quality. This bill maintains standards, protects classroom stability, and honors the intent of the Cultural Exchange Program. We respectfully urge your support and stand by to answer any questions if you have them. Thank you.
Thank you. The Legal Clinic in support.
Thank you very much. My name is Amy Agbiani. I'm president of the Legal Clinic, and this is Tina, our policy director. We stand in strong support of this measure. As the previous speakers have said, we're not asking for changes in requirements for licensure asking for an extension by 2 years, which would meet the visa maximum of the federal government. I believe that currently this program meets a need that Hawaii has. There is a shortage of teachers, and the teachers that are brought here actually have done very well. And from what I gather by talking to some of the principals and teachers, they do perform very, very well. As a Filipino, I'm also very connected to the Filipino community, and the majority, if not like 99.9% of the current J1 visa teachers are from the Philippines, and I believe that they are continuing to teach quality in a quality way and actually meet a community need. So we strongly support this.
And if I may just add, we also submitted written testimony in full support of this measure, and we're happy to answer any questions.
Thank you. UH College of Education.
Oh, hi. Good afternoon, Chair Matayoshi, Vice Chair Grandanelli, members of committee. Nathan Murata, Dean, College of Education here at UH Manoa. And I'm here to also provide and answer any questions that the committee may have with regard to this particular bill. Thank you.
Thank you. Anyone else in person or on Zoom who'd like to testify on this measure?
Aloha, Angela Melody Young, testifying on behalf of CARES. So in strong favor of this legislation, because it helps immigrant teachers to create alternative streamlined permitting pathways for J1 visa holders, aligning the teaching authorization with the 3 to 5 year duration period of their exchange program, and it removes barriers like for example, the very rigorous state exams, and it helps with providing greater job security for teachers to help with financial stability. And so my mother came to the United States on a student visa, although she was a certified teacher in China. And my grandmother survived the Cultural Revolution and the takeover of the Communist Party. She didn't teach, probably because the licensing standards within and between the foreign countries were very not flexible in this time period. And so something like this, if enacted, would be very helpful to immigrant teachers in this generation.
Thank you. Also, anyone else wishing to testify? Just noting an additional 52.
Vice Chair. Just Hawaii Coalition for Immigrant Rights, we're gonna stand on our testimony in support.
Thank you. Also noting an additional 52 individuals who submitted written testimony in support. Members, any questions?
I've got a bunch. I just figured other people would too. DOE? What percentage of J1 teachers do not end up passing the praxis exam and are not able to teach in the 4th and 5th years?
Currently they can't teach in the 4th and 5th years because the permits only allow them to get to the 3rd year. So
I thought if they were able to become certified if they passed the praxis and they could teach in years 4 and 5.
So there's multiple steps to becoming a fully licensed teacher, which includes passing the praxis, but it also includes going through the evaluation of coursework. And there are challenges in that process of the coursework being evaluated.
So how much coursework do they need to do in the first 3 years in order to teach in years 4 and 5?
So it'll depend on how the evaluation of their international transcript is completed, and right now there's been challenges, so I can't tell you for sure.
So some might have all that coursework considered completed and some will start from zero.
Potentially, actually, it's probably a better question for the teacher standards board on that particular issue.
What steps is DOE taking to try to ensure that these J1 teachers, or honestly all emergency hires in this situation, are able to pass those 3 years and become a certified teacher?
So there's support for, there's some grow your own support in terms of providing some scholarships. So I'm gonna speak more broadly about emergency hires. I'm not sure that the J1 teachers would be eligible or prioritized for those funds for tuition support if they need additional coursework. There is also support in terms of some support for the praxis in terms of getting it done. We just completed a survey of our emergency hire teachers, and a lot of them have challenges in completing all of the requirements for license within the 3-year period, and said more time would be helpful. In part, some of it is timing, they're learning a brand new job, and so the demands of the job plus trying to take the additional coursework and pay for the additional coursework is challenging. And we've done some deeper dives around the timing of some of the steps that teachers need to take, and a little more time would help more of them be able to successfully complete towards full licensure.
Has DOE, I guess there's 2 parts, right? There's praxis and then there's the coursework. Just on the praxis exam, does the DOE offer free courses to prep teachers for the practice exam? I mean, we do a bunch of prep for students to take standardized exams. It kind of surprised me if DOE didn't do the same for its teachers.
I would need to check on that. I'm trying to remember if we do. I know there's some support, but I can't tell you I will get back to you about the type of support that's available.
And as far as coursework goes, I mean, I'm assuming they would go through one of the universities in the state, is that correct?
For the
other coursework.
So not specific to J1s or not specific to J1s?
Emergency hires, but including J1s.
So including J1s, there are both in-state and out-of-state programs that are approved by the Teacher Standards Board. There's a few that are considered, few that are post-baccalaureate, which would be probably the fastest way to getting.
I guess we should be talking to the Teacher Standards Board about this. That's fair. Sorry. So what kind of options are available as far as coursework goes? Are there any online-only options for the neighbor island?
Well, that's
teachers?
interesting because for J1 visa holders, if they already have a teaching license, like they've gone through a teacher education program in their other country, then all they need to do is take the praxis, certain praxis, like usually 3, to make sure that they pass and they're ready to be in front of our students. So there isn't coursework. It's only when they have a bachelor's degree only that's not in teaching, then they may require the coursework. There's a few J1 visa holders that have had that, but most come over here with a teaching degree. But we want to make sure that they're in front of our students. Most go in elementary and special ed. And so we want to make sure they pass the praxis, and reading and writing seems to be the most difficult for them, the core reading and writing. That's the one. We recently saw an email that DOE was offering support, so I hope they are, because we've been pushing for that.
Just to give us an idea, I mean, is it like 90% of the J1 teachers that come over had a teacher certification and therefore just need to take the praxis, or is it?
Yes. I mean, they need to do that, and they have 3 years to do it because they can have an emergency hire permit for 3 years. And then once they do that, those years that they were in teaching will count toward their standard license, which becomes a 5-year.
Okay, so really the vast majority of the J1 teachers, the praxis is the barrier. Is that fair?
Not a barrier, but yes, it prevents them from getting because we want to make sure that they're okay to be in front of our. We had a mathematics teacher from another country that came here, and she's put in a 2nd grade classroom. It's like, ooh, ouch. I mean, because even here, that would be hard. So it's just to ensure that our students are getting quality teachers in front of them that are ready to teach those basic reading and writing skills, especially since it's all mostly going to elementary.
So praxis, they pass the praxis and then they can stay for the full 5 years generally?
Then they can get a license for a provisional license that can become a standard license after they've been here for 3 years, and yes, it will switch to a 5-year standard license.
And it doesn't matter if they pass in the first year or the third year, you still need those 3 years, and then on year 3 you have to.
Yes, yes.
Are there any other alternative pathways available currently?
For J1 visa holders
J1 visa holders, I guess we could expand it to
and emergency hire
hires,
permits,
but
there's
really
also a
we're trying to
Hawaiian
talk
permit, which is longer, but that's to help get Kaiapuni teachers, like Hawaiian immersion teachers, so there is that.
Okay. Sorry, Dee, did you want to add something?
I have practice information. Information and practice, we are currently offering free praxis preparation for all J1 teachers. And so that's to prepare for the test. There's a cost for the test. When the teacher successfully completes, they can be refunded the cost of the test.
Okay, so it's only if they pass it they get refunded.
Correct, so they have to upfront the cost.
Is that a program available for emergency hires as well? Is it just J1s?
Check. I guess one of the things I wanted to make sure everyone knows is that the teachers are evaluated by school administrators annually. So based on classroom observations as well as other documentation teachers provide. So in terms of the quality, they are being monitored for the quality of their classroom instruction. And again, I just would say that part of the question becomes what's the alternative to providing an extension to our emergency hire teachers. It means recruiting new people for the positions and then onboarding and training new people.
Which is a great segue to UH College of Education, because I think what we're trying to do here is patch a hole instead of healing the wound, and that's where you guys come in. College of Ed, are you still there?
Yes, I am.
Okay, so I feel like this is a tale as old as time, unfortunately. Way back to when I was teaching, it was already an issue, and far before that. Why is the Department of Education, or why is the College of Education having so much trouble putting enough teachers in our public school system to at least fill the gaps, if not start to close the gaps?
Well, yeah, we certainly try our best to fill as much of the gaps as possible, being the largest provider for the state of Hawaii. And on average, we're close to over 200 annually, with about 400 plus in the pipeline. But again, the efforts that we put in with regard to trying to fill those gaps clearly do not meet. And we do have programs and things that we are doing at Manoa to continuously look at our recruitment efforts in ensuring that we get the more and more people in the pipeline, particularly local students and all. So yeah, we are trying. It's the recruitment becomes a challenging piece. There's still that perception of the teaching profession overall not being getting the kind of recognition that it should receive as a professional entity. So, and I think we keep trying to work with it. We work with our partners.
But what kind of things specifically are you doing?
Oh, well, specifically, for example, I know locally here we're looking at a UH system-wide 60-60 plan. In other words, those that are currently in the community colleges, an easy streamless pathway into Manoa or to the other 4-year UH system programs. There's also the stipend program that was mentioned earlier with the Grow Our Own, and the scholarships programs that we offer to our students up to almost $500,000 total for 250 students. So incentive-wise, we're trying very hard in that respect. Also looking at the extramural funding for our early childhood care program, the new programs, to also beef that up. We also are recruiting in the high schools as far as developing and maintaining that pipeline, with regard to, for example, the Educator Rising initiative, which we work closely with the Standards Board and the department in getting, high school students across the state to begin at least start to have some interest to develop professionally to become teachers.
So how effective have these programs been?
How
Because,
effective?
I mean, is there are you noticing an increase in the number of teachers you're putting out,
Oh,
or?
yes, well, with the stipend programs, yes, there is currently, this, for example, in our Grow Our Own and our SPED program, there's actually a wait listed of individuals that would want to have some tuition support. That seems to be the one that really drives a lot of the recruitment efforts. The 60-60 plan and the Educational Rising, those are more long-term initiatives. And of course, we do the recruitment events every year, but the stipends, the tuition incentives with regard to providing that kind of support seems to be one of the main drivers in our recruitment efforts, favorable recruitment efforts.
Okay, because I mean, I want us to at some point be here not talking about J1 teachers, honestly.
Yes, yes.
And I think you guys are kind of the key in that. So it's good to know that you're trying things. What do you think a reasonable expectation or a reasonable goal would be to set for you folks in the next 5 years? If you're graduating 200 a year right now, what do you think a reasonable goal would be?
Well, I think our reasonable goal would be at least double what we currently have. I think that would be a reasonable goal. Currently, at present, we have from anywhere from first, second, third year students. When I say 200, a little over 200, those are our completers. We have over close to 480 somewhat students that are currently in the pipeline in all content areas. And post-bac, advanced programs, all the licensure programs. So I think if we keep this momentum up and keep the students that we have in the pipeline, I feel pretty confident that within 5 years we could double our capacity, and if not more, So very optimistic in that, Chair Matayoshi.
No, that is great to hear. That is far higher than the goal I was going to set you. So
oh, okay.
You sort of dug yourself a hole, but I appreciate it.
Yeah.
Okay. Sorry, I've just one more question for you. As far as teacher retention, I mean, graduating a lot of teachers is great. First year and second year teaching is incredibly difficult. I think if you can get teachers over the hump, that's a big retention bonus. Is UH doing something to try to get those teachers over the hump even after they've graduated, or is that more the DOE or?
Yeah, well, we do have a program that it's like a project Equal Access where we work collaboratively with the Department of Education and working with the induction teachers. What we do know from Manoa is concerned is that after 5 years, over 90% of our UH Manoa graduates are still employed after 5 years. We have data to show that. So we know that our graduates are there and are continuing beyond the traditional 2 to 3 to 5 year benchmarks, if you will, and are still employed, over 90% of our graduates. So we have a department, a special ed program where more of our special ed teachers are being mentored. But again, a lot of the mentoring that we do with respect to the induction teachers are also in collaboration with the Department of Education.
Okay. Yep. Sure, if you'd like to add something. That's pretty much it.
You're absolutely correct. The first 2 years of teaching is extremely difficult, and we have a outstanding, I'll say, teacher induction and mentoring program where every first and second year teacher is assigned a mentor to support them throughout their 2 year tenure. I will send you the report on the results. They're surveyed. It has the data on how the program has helped them, how many teachers have remained in the positions, and it also gives the specifics of how that year 1 and 2 induction and mentoring support help them remain in the profession. So I will get you that full report.
Okay. And sorry, how many J1 teachers are there right now in our schools?
365 this year.
365. So if they go up to 400, I mean, we can close that gap pretty quick, I'm assuming.
Yes.
Okay, thank you. All right, thank you.
Any other questions, members?
Oh, Gregor, did you have a question? Go ahead.
DOE. So university mentioned they produce 200 annually. What's the demand right now for teachers?
So the demand is annually, we hire about 1,000 to 1,200 teachers annually. that includes rehiring that may include emergency hire teachers, including our J1s who are considered year-to-year hires. So we are looking to fill probably about 1,200 annually.
So 200 annually from the university helps supplement that 1,200 that you need as a demand. And you also hire from out of state, J1s, so forth. So the demand is quite high. What is the, does that demand also meet the retirement of teachers, like factoring that into that demand as well?
So the numbers I mentioned are our track record over the last few years about how many positions we're newly hiring for. So it takes into account the retirements that have happened. It doesn't look at changing trends in retirement.
So it looks like there's a big demand, and this does help, not only for retention but also hiring. And I commend you for trying to close the wound or prepare the wound, because the only way you can get to the hospital is you've got to be alive. So right now we have a wound that we're trying to fill, and so this is one way of doing that. Thank you.
Sorry, I have one more question for you. If the praxis is the problem, why not just have them make sure that they pass it wherever the J1 teacher is coming from before they come here?
So praxis is not the only issue, but
For the 90% that already have the teaching credentials, why not just have them pass it in the Philippines or whatever other country they're coming from for J1 visas, and then arrive here ready to go for 5 years?
I could ask about that. I can tell you that there's a competitive market for J1 teachers nationally. There are multiple other states that have a particular, they call it like a guest license or international teacher certificate that has a particular the duration that would be equivalent to the visa. So something like what's being requested in here. So we have learned, actually this year in our recruitment for J1 teachers, we have received, fewer people have accepted our offer because they're finding that they can go to other states where they know that they can work for 5 years.
Go ahead.
Thank you. Just to ask about that competition, other states are probably cheaper in the cost of living too. So that factors into the decision not to come to Hawaii but other states. So this bill does help make it more attractive for them to come to Hawaii.
Yes, it would remain, make us more competitive in terms of someone doing the visa knows that they can stay here for potentially up to 5 years, rather than 3 years and then having to move and look for another place to work if they want to extend.
Thank you.
Members, any further questions? Okay, we'll take a brief recess. Recess. All right, reconvening. Members, we have a number of bills on the agenda for decision making. First up, we have HB 1946 HD1 relating to registration of timeshares. Chair's recommendation is to adopt BCCA's proposed amendments. It's already got an effective date, so no need to worry about that. Members, any comments? Vice Chair for the vote.
Voting on HB 1946 HD1, Chair's recommendation is to pass with amendments. Is that it?
Yes.
Chair and Vice Chair vote aye. Representative Chen.
Aye.
Representative Ilagan.
Aye.
Representative Ichiyama. Aye. Representative Iwamoto. Excused. Representative Kong.
Aye.
Representative Lowen. Aye. Representative Martin. Excused. Representative Tan.
Aye.
Representative Perrick. Excused. Chair, your recommendation is adopted.
Okay, thank you. Moving on to HB 1515 HD1 relating to workers' compensation. Chair's recommendation is in HRS 386-1. We're going to add to the definition of healthcare provider the occupational therapist and physical therapist language, just to mirror this bill, language in this bill. Members, any comments? The Vice Chair for the vote.
Voting on HB 1515 HD1, Chair's recommendation is to pass with amendments, noting the excused absences of Representatives Iwamoto, Martin, and Perrick, unless otherwise noted for the remainder of the measures on this agenda. Are there any representatives voting with reservations? Any noes? Chair, your recommendation is adopted.
Thank you. Moving on to HB 1514 HD1 relating to workers' compensation. Chair's recommendation is to adopt DLIR's proposed amendments and to change the 90-day deadline to 120 to submit plans after the initial evaluation report, and also to add a provision allowing the director's discretion to extend the deadline if the director so chooses. Members, any comments? Okay, Vice Chair for the vote.
Voting on HB 1514 HD1, Chair's recommendation is to pass with amendments. Any reservations? Any noes? Recommendation adopted.
Thank you. Moving on to HB 1648 HD1 relating to workers' compensation. I spoke to the previous chair about this. We're going to be reverting this bill back to the original language, adopting DLIR's proposed amendments and affecting the date. Members, any comments? Okay, Vice Chair for the vote.
Voting on HB 1648 HD1, Chair's recommendation is to pass with amendments. Any reservations? Any noes? Recommendation adopted.
Okay, moving on to HB 1644 HD1 relating to consumer protection. Chair's recommendation is to adopt the proposed amendments by the Contractor Licensing Board, adopt the amendment proposed by the Hawaii Credit Union League, and to also adopt DCCA's proposed amendments. Yep. Members, any comments? Okay, Vice Chair for the vote.
Voting on HB 1644 HD1, Chair's recommendation is to pass with amendments. Any reservations? Any noes? Recommendation adopted.
Okay, moving on to HB 1619 HD2 relating to electric vehicle infrastructure. Chair's recommendation is to pass this as is. Members, any comments? Okay, Vice Chair for the vote.
Voting on HB 1619 HD2, Chair's recommendation is to pass as is. Any reservations? Any noes? Chair, your recommendation is adopted.
Okay, moving on to HB 1571 HD1 relating to condominiums. We'll be deferring this measure at this time. HB 1810 HD1 relating to charitable solicitation. Chair's recommendation is to delete subsection H2 as recommended in Goodwill's testimony. Members, any comments? The Vice Chair for the vote.
Voting on HB 1810 HD1, Chair's recommendation is to pass with amendments. Yeah.
Yes.
Okay. Any reservations? Any noes? Recommendation adopted.
Okay, moving on to HB 2475 HD1 relating to labeling requirements. Chair's recommendation is to pass this as is. Members, any comments? Okay, Vice Chair for the vote.
Voting on HB 2475 HD1, Chair's recommendation is to pass as is. Are there any reservations? Any noes? Recommendation adopted.
Okay, moving on to HB 1645 HD2 relating to liability. A very important bill, I think. Based on the testimony, Chair's recommendation is to delete section -2 on pages 4 and 5. Joint and several liability is the main aspect that I think is going to do the most impact on insurance rates on this bill. But we will be adding a note to the committee report that future committees may want to determine that if the indemnification of the state is an important part in the insurer's calculation for the rates that they're offering, then they should consider at least adding part of -2 back in, considering indemnification of the entity to the state. Members, any comments? Vice Chair for the vote.
Voting on HB 1645 HD2, Chair's recommendation is to pass with amendments. Any reservations? Any noes? Chair, your recommendation is adopted.
Okay, moving on to HB 2301 HD1 relating to school licensure. We will be deferring this measure at this time. Moving on to HB 1889 HD1 relating to school psychologists. Chair's recommendation is to pass this measure as is. Members, any comments? Okay, Vice Chair for the vote.
Voting on HB 1889 HD1, Chair's recommendation is to pass as is. Any reservations? Noes? Chair, your recommendation is adopted.
Yeah, thank you, members. Moving on to HB 1840 HD1 relating to education. A lot of great discussion on this bill. I do think that the emergency hire teachers that are not J1 teachers should also be given and afforded the same opportunity. Chair's recommendation is to amend the language in this bill to delete it and to insert the language for HB 1825 with a defective date. HB 1825 extends all emergency hires basically for the 5-year term. I do want to add a 5-year sunset to this bill as well. I do want the parties to be working towards not needing this bill and for it to be reverting back to how it originally was. So I'm hoping, per the testimony from UH College of Education, that in 5 years we'll have made enough impact in the teacher shortage year to year, both through teacher retention and through recruiting and getting new teachers through UH Manoa, but also all of our other colleges and higher education institutions in the state, that we hopefully will not need this in 5 years. I'm going to be adding a requirement that the UH College of Education increase its teachers' graduate output by 100%. I was only going to give him 30. The guy said 100, so you know what? I'm going to go with it. We're going to double it in the next 5 years as a goal. I'd like an annual report to the legislature on the progress of these efforts and the effect of these efforts. Also adding a requirement that the DOE, which sounds like they're already doing mostly, but that the DOE provide training for emergency hires to help them to pass the required praxis exam, not just for J1 teachers, but for all of our emergency hires teachers as well. I also want to require participation in this training for emergency hires in their 3rd and 4th year. That's including J1 teachers, but also non-J1 teachers. If they want to have the extension into the 4th and 5th year after their 3 years, and they haven't passed the praxis exam, they can have the next years, but they need to at least be enrolled in the course to give them the best chance to pass this exam and become certified teachers. Members, any comments? Yes, Vice Chair for the vote.
Voting on HB 1840 HD1, Chair's recommendation is to pass with amendments. Are there any reservations? Any noes? Chair, your recommendation is adopted.
Okay, thank you, members. We're adjourned.